All right. Well, hello, and how are you today? I believe that what I'm going to have to do, it appears, is record this video. It may not be live this go round because I am not going live at 4 o'clock. And I just received a notification that I need to turn the video or that it couldn't be turned during the live feed. So hopefully, you know what, I'm just going to keep it going. Because it is recording. I'm going to believe for the best and edit it in InShot if necessary. So good day and welcome to Evolve Weekly with your girl, Tigress Sydney Acute McDaniel. And today, yes, we are discussing Breonna Taylor and the ethical issues that are core to this case, the legal issues that are core to this case, and some attorneys may look at this video and may suggest that I'm confusing ethics and law. Some attorneys may be very self-righteous and suggest that I am throwing disdain on the legal community because I'm suggesting that there is no ethics in the body of law. Well, this is the only statement that I'll make in response to either one of those. And this came from a law professor. And it doesn't mean that, you know, law professors are still human. So are judges. So is everyone on this planet, to the best of my knowledge. All right. I know no deities. I know no humans on earth that have the capacity of omnipotence, nor are they all-knowing, and nor are they omnipresent. Okay, so, but ironically enough, what I learned at North Carolina Central School of Law in 2002, that was when I was first enrolled, contrary to many beliefs or disbeliefs, I answered a question with my very reputable, widely known ethical disposition, right? My kind of mother's eye objectivity. And I really am humbly and confidently proud of the objectivity that I'm able to display. So I'm able to look at situations and I'm able to hear all perspectives and able to handle resolution or guide resolution very well because of that, you know, that ability. And so I answered this question in class in an ethical way, and the teacher corrected me. And in fact, she scolded me and she told me that basically like, silly rabbit, there's no ethics in the body of law. And I was like, okay, well, all right. That's awesome. That's awesome. So what I'm going to do is I'm going to begin with my standard affirmation, as I've told you before. May I enlarge our thought. May I enlarge our enlightenment. And may I not further divide with what I share today. Okay, so we're going to go over some definitions, and I believe that these are necessary. In my core field, which is science, we have what we call assumptions. The assumptions are not colloquially applied. So colloquially, when we say assumptions, we generally are talking about things that people have drawn conclusions about, and they really don't have sufficient information or evidence for the conclusion that they've drawn, right? However, assumptions in the scientific method are those things that we can generally infer from the parameters that we have for our study, okay? And so inference is a step up from, and arguably, and even legitimately, 2 steps up from colloquial assumptions. And even in the body of academia, an inference can be equivalent or there, like just slightly thereunder to a deduction. And we know a deduction is generally a very sound decision or the sound conclusion drawn on the basis of sufficient information, right? And of course, you know, my economic background, which I love so much, and I love the ceteris paribus, which means what? All things being equal. So that just is that E that we include in all of our, we explicitly consider the E, the error that can exist with any study or any contemplation or any analysis, right? And so that applies also in every other aspect of life, even though it's jargon from the economics, field of study. Okay. All right. So it is important then that we establish certain assumptions, because there's a scientific method with the field of law that I don't believe we all consider, and myself included, even though I may have an intermediate level, because I'm not a layperson. Most people know this, even police officers, even sheriff deputies, judges, they know it full well, even though they obfuscate till they are blue in the face. They know that I know exactly what I'm talking about. And not just, and I'm saying that colloquially, but they know that I am not a neophyte when it comes to understanding what they intend to be their scope of comprehension of law. So I may not be fluent, and I'm working on that, but I may not be fluent in the comprehension of law, but I'm damn close, especially for someone who is not a licensed attorney and has not obtained their Juris Doctor. I believe and assert that I may have, on occasion, and depending on the subject matter, I definitely have an expertise that rivals, if not completely overshadows, the understanding of some individuals who are licensed legal professionals. Okay, so, and I definitely, my recall is definitely generally far superior. And I believe that this is the reason, and I'm not saying this to throw any shade to some of the licensed legal professionals, but a lot of us know now, if you've reached 30 years old, you have generally had to appear in court at some point. You've generally had to hire an attorney at some point, right? And we soon realize that who we think we're hiring, right, or who we think is adjudicating the case, we have this, and it's an unfounded presumption that is assigned to judges and attorneys, that somehow they are academically superior or cognitively superior, and that's just not the case. And again, this is not to throw shade. This is just factual. And the reason being, and I have said this a million times over, and I'll continue to say it. I've said it to judges during open court sessions in a respectful manner, but there's no way that anyone, and you shouldn't allow anyone to assert some type of cognitive eminent domain or superiority over you, when the whole concept or the whole paradigm for the comprehension of law or the study of law is based a lot on memorization. And it's understandable in some regards because there is a checklist of sorts. There's a rubric, if you will, if-then scenarios or iterations. So if this case, then sorry, not case, because I don't want to confuse it. That's why I want to go back to the assumptions or the definitions that we're going to, so we are all on the same page, so that when I begin speaking, that at the very least, I can best articulate from the assumptions that I've set for this particular video, okay? Now, there may be times where I may be invited for political forums or public forums, and there may be a different set of assumptions or a different jargon. And I try to be very mindful because remember, my expertise is completely interdisciplinary. And so I do speak economics fluently. I do speak science fluently. That has already been proven. I've already achieved my candidacy as a doctoral candidate in my field and respective subfields of my expertise. So that we're not questioning. But admittedly, for the field of law and then the application of different aspects or different academic fields that would come into play as we continue in this process of trying to figure out how do we evolve. And we've said it in many different ways, but I believe all these terms are generally synonymous. We want transformation. We want revolution. We want evolution. We want a more perfect union. I assert that those are all essentially intending to communicate the same thing. And so, and admittedly, there will be arenas where, like, I'm not an expert in engineering. However, that is core to my field of expertise. And so I've had to obtain and undergo, take coursework to have more than just a working knowledge of engineering. So I have a lot of physics, a lot of math in my, on my transcript and all those things. So all I'm saying is, as we continue to go on, and I suggest to you that, oh yeah, I can be in this conversation when it's not necessarily on topic to just science or just economics or just law. And I'm telling you this because, and I'm hoping that you have an appreciation for me in that regard, because that's another thing that I have been advocating for, is that we have way too many people who are running for office. And this is why we have this kind of buyer's remorse, if you will. And again, I'm saying this colloquially. I'm using a very strong jargon-based term and using it colloquially to apply here, but I do not advocate for buying a politician. I am completely, vehemently against the whole notion, okay? But what I'm referring to is that you elect someone, and that just metaphorically, your vote is effectually your tender, and we put up this tender, this vote, to put someone in office, and then come to find out they're really not qualified. They really don't have a good ethical disposition that you were assuming that they had. They go figure, coinky-dink. Maybe just hearing sound bites from someone is not sufficient information to base a decision to vote for somebody on. Newsflash, right? Okay, so I want you to have an appreciation for the fact that I will be a forever learner, a forever listener, a forever researcher. I will not sit on my laurels. According to my quote-unquote academic status right now, some people think I've already graduated. They think I've already kind of reached this level. I haven't. I still must undergo the final defense. I cannot call myself a doctor. I cannot put PhD behind my name. I can put PhD ABD, and it does have some weight. It of course, colloquially, it has some weight. Academically, it has some weight, but it does not in any way, shape, or form assign the same efficacy that is communicated with the actual PhD. And of course, this is still contingent upon the individual persons, because we know that, again, I'll say this over and over and over again, people are going to be people all day long, and we all, I don't care who tells you, well, no, I would never do that, and I'm so perfect, and I'm just this, and all these things. We all have the capacity for evil and good. We make our choices minute by minute, hour by hour, day by day, on whether or not we're going to do 60-40 today, 70-30 today, 50-50, 80-20, 90-10. Some days we achieve 100%, or we get very close. But it's just, you know, we all have the capacity for that. And so just the title alone, it does not, it's not a guarantee of high ethical rigor. Okay, so with that being said, we're going to go into the definitions, because it is very important to understand this as it relates to Breonna Taylor's case and every other case that we have seen publicized and really vetted publicly from different, you know, sectors of our communities and from the larger communities, like our ethnic, you know, communities, and then, you know, then they're under the LGBTQ plus community, and what we call in academia, they're called imagined communities. And that is not to be mean or condescending, and I'm not sure who came up with the term, because the term does kind of straightly have this kind of condescending overtone, because it's suggesting that the community that I identify myself in is imagined and only imagined. And they're just talking about the academic term, presumably, because of course I don't know the person who actually came up with the term. So please don't shoot the messenger. Okay. All right. But basically all I'm saying is that these subgroups that we identify ourselves as being part of, they come into play, especially in these situations where we're discussing cases that have so many layers and complexities. We would think that it would be cut and dry, and I'm going to share some of my insight on this case. Now, I will start off by saying, before we do our assumptions, number one, I too believe that there was gross negligence, not just, and I believe that there was criminal conduct on the part of the officers who executed the search warrant, albeit a no-knock. So that means that, number one, we know that a warrant, because we also had to go over that, and we'll do that in the definitions as well. But I'll go ahead and do it right now. So the warrant, let's clarify this right now, because there was a lot of discussion about, well, they didn't have permission to go in the manner that they did. Well, a no-knock warrant does legally, and again, this is not because I agree. I actually do not agree with no-knock warrants. Generally, even a no-knock warrant would still require that the officers announce themselves and then give a reasonable amount of time for a person or for the occupants to answer the door. And that's just for obvious reasons, because even many courts, even high courts, even our U.S. Supreme Court, 4th Division, I think 4th Circuit, has decided that even in Breonna's case, as recently as Breonna's case, that even though they had, and I'm using these terms loosely, law I believe they will say effectually held their hands in having to decide that the police officers were indeed eligible for that qualified sweeping immunity. Now, their opining, however, states very clearly oppositely. So that's a very interesting thing, and I want to make sure that you all are aware of that. I'm not saying that that makes any of this okay. Do not go out trying to say, well, Tigress McDaniel, I bet she thinks, she rock with them that think that this is okay. Don't do that. Don't do that. Don't do it, friends. Don't do it, okay? It won't be productive for you at all. I've told you a million times over, even where there are individuals who will try to throw dirt on my name, trust and believe, I come from a family rich in positivity, and I believe very strongly, and yeah, that means that we're still imperfect at times, but that means that generally speaking, when I am aligned correctly, there's nothing you can do, nothing you can do that will somehow expose me to the truest intentions of rumorments and naysaying and lies and things of that nature. It will always return to you void. Okay? All right. So, because it has always gotten back to me. I just trust the universe in that regard. It has always gotten back to me. I've always been able to see people have to eat crow. I've always seen it 1,000%. And that just lets me know that you stand on the truth, and the truth is a solid foundation to stand upon. And I'm going to stay there. That's what I'm going to stay. I'm going to stay right there because it works for me. Okay, so, but this Fourth Circuit, and let me pull it up. I mean, I have it up for you. You can't really. There you go. You can see. Okay, so the Fourth Circuit. This was in reference to Clarence Jamison. He was an autistic patient and evidently found himself in one of these traumatic police incidents of gross negligence or brutality, criminal contact, bad judgment, improper training, all those things that we have seen. And so this was a case, and I would imagine it would be the state for Clarence Jamison versus McClendon, okay? And this was the officer who had caused Jamison harm. And again, I've told you before, if you haven't already, Lexus is available to citizens. You don't have to be, to my knowledge, and I've seen the commercials and I've seen it even within the portal, that they offer plans for you to gain access to their database without being a licensed legal professional, without being a law student. Okay, so the Fourth Circuit wrote, although we recognize that our police officers are often asked to make split-second decisions, we expect them to do so with respect for the dignity and worth of Black lives. Fourth Circuit, hold on, and I'll put it up there. I'll post a link to this, but you won't be able to get to it. I need to re-up my Scribd account, and that, if for those of you who are not familiar with the Scribd, SCRIBD accounts, they allow you to upload documents and then share them with whomever your audience, or your group is, right? So I found this especially interesting. And above it, so preceding it directly, it says the Constitution says everyone is entitled to equal protection of the law, even at the hands of law enforcement. Over the decades, however, judges have invented a legal doctrine to protect law enforcement officers from having to face any consequences for wrongdoing. And of course, this is coming from the plaintiff side, right? The doctrine is called qualified immunity. In real life, it operates like absolute immunity, and it does. So there are no lies in that statement from the plaintiff. seems a bit, there will be some licensed attorneys that will say, well, that's a bit editorializing. You know what? Okay. All right. I am referencing legal documents, legal records that have nothing to do with Tigress McDaniel. Okay. So let's take Tigress McDaniel out of it and take your monomaniacal obsession with all that I am. And we're going to put that in the trash because it has no bearing on this binding legal document, because it has become a binding legal document. Now, the decisions therein may not be binding, because that's going to be part of what we're going to discuss here about the interpretation of law. And that's where, when I keep saying to you, obfuscation is our biggest issue. It is our greatest enemy. As far as legal reform, prison reform, transformation, evolution, a more perfect union, all those words that we use to say, hey, we don't like how this is going. We need to get this together because this does not reflect the consensus of Americans, right? Okay. All right. So, number one, our assumptions. The assumptions that this is jargon that you need to know, that we all have to be on the same page about, no matter how much we don't like it, as it relates to right now. The reason why I say as it relates to right now is because I too do not want to see us continue on this road of legal chaos. It's not justice. It's not even consistent. It's not consistent per case. It's not consistent per state. That's another thing. That's another one of my huge contentions. It is not even consistent by state. And we're not talking about, because I can see scantily or even properly where the application would have to do with, okay, well, this particular state, we have a unique set of parameters or circumstances. And so for this state, the law has to read like this so that it covers our uniqueness, right? I get that. But we're talking about these higher level laws. They're not interpreted the same way from state to state. I think that's a problem, especially. And I am very, very, that's one thing that I love about where we're going and the country as a whole, is our ability to be able to generally freely roam about, right? So you don't need a passport is what I'm talking about. I'm talking about the the literal aspect of it. You don't need a passport to go from Georgia to Florida. You don't need permission from the governor. You don't need permission from your mayor to go from city to city. If you want to go from Charlotte to Greensboro today and back again and do that trip 8 times, you are more than welcome to do so. You'd be tired as hell, but you're more than welcome to do so. There are enough hours in a day for you to do it, 4, 5, 6, 7 times if you just that beast, okay? So, case law. All right, so number one, well, no, let's go statements. Let's do it in order. Statutory law. So statutory law is the law on the books, right? The law on the books. Now, sometimes you'll hear it interchangeably used with case law as the law on the books, because effectually they both are recorded. However, state law, it is the predecessor, if you will, to case law. And I think most of us generally know this, but I'm just going over it for, just so we're all on the same page, because I believe very strongly we have to have sufficient information so that we can move forward. I believe it needs to be the same way, even with, like, for instance, with Ice Cube's contract. If you don't understand the academia and, behind the intention of the language in the contract, then it's going to seem like he's really not doing something. And mind you, remember, I've reminded you before that he is working with others, and he's working with individuals who I very, very publicly have said I rock very hard with, like Dr. Claude, right? A lot of you already know that he and I share a lot of the same ideas and philosophies of thought, if you will. So he's not just doing this on his own. And this is not just done arbitrarily. There's academia behind this. There is study behind this. This is thought. This is elders who have been through the process and who've seen it up close. Some of us we haven't seen it up close. Because I've not been in an actual position of I've not been in office. I've not yet been elected in office. I still yet have to say that I've seen it from the outside looking in, even though I have a closer look. Does that make sense? So it's like the difference between you may be sitting in the balcony seats and I'm in first row. I'm still not on stage, and I'm definitely not behind the stage. I'm not backstage, but I've got a closer look. These individuals who have been working with Ice Cube, they are backstagers. Some of them, most of them VIP backstagers. Okay. All right. So we should at least be mindful to listen and then figure out, okay, please, start from here. Say, you know what? I see what you've written out. And when I read it at first glance, it's not articulating well with me. And I see all of these holes that really just don't answer all of our issues that I feel are, and that I know, because of course your issues at the neighborhood level are inseparably valid. But they're speaking right now, remember, on a higher level because they're starting the conversation. They put it out that they have not intended this to be the final conversation and this is the decision. They've started the conversation and they've started the process. Okay. So, all right, and I'm doing this today. Okay. So we got the statutory law. Now, mind you, just because there is state that we think is self-explanatory in the term statutory law, it is not necessarily just state law. So statutory does not mean that, okay? And instead, you can have federal statutory law or you can have state statutory law. It's just the law that's the law that is the predecessor. That's what is revised and codified and ratified by the legislators that we elect, okay? Then your case law comes into play, where these statutory laws are generally the guidebook. Now, there are parts of the law that have become more and more explicitly articulated with all these very detailed stipulations, because as there are cases that are heard, they build upon it, right? Now, they're ratified. So they have gone beyond case law and they've been ratified into statutory law. However, the case law is different from that, because the case law remains just in that state. Like, it's a particular case where the circumstances were just unique and there was nothing in the statutory law that really talked to how to handle this particular type of case. And so the decision made on that sets a precedent because of it, and then becomes effectually case law. Constitutional law, what? That's our prevailing law. Again, it is the guidebook. And it says, okay, this is what, I don't care what you do state-wise. Well, you know what I'm saying, colloquial, because, don't take my words. You know what I mean. I'm trying to be mindful that I know the people who are tuned in. And I want to make sure that I don't lose you throughout the process, because I am very good at talking colloquially, and I'm very good at talking higher level academically. But that's not going to work well for a YouTube live session when we're trying to really be on the same page. I want us to be sufficiently informed. I want you to be walking around like, I got this. I know, no, I know exactly what I'm communicating. I know why, I know the when, I know the what, I know the where, period. We're not going to do this foolishness anymore. We're going to be on the same page. And in order for Black America to get on the same page, and admittedly, for all other ethnic groups and those subgroups that I mentioned before, for us to stop having so much division, because the division is effectively like the Tower of Babel. And it's not that we're babbling, because I don't like that when people have taken the Tower of Babel proverb, which is a pretty, even if it was a lie or made up story, it's a pretty profound kind of proverb to kind of use as a life lesson. If you don't have the same circumstances as me, if you didn't grow up in a single parent home, there are likely going to be times where you don't understand my perspective. Or if you didn't grow up in a military family, and I did, there are going to be likely times that you don't understand my perspective. It doesn't mean I'm babbling. It doesn't mean that my perspective is invalid. It doesn't mean that we can't find a common ground. It just means that we need to establish that commonality and listen and understand the jargon. You can compare them the same way, like the academia, the different subject areas. You can apply it the same way here, okay? And if we have an understanding of this, then we can all look at this. I want us to be to the point where we all look at the same news station, and after the broadcast, we say, "Oh, I got it. Did you understand it? You got it? Oh, yeah, we all get it. Okay, and now this is what we want." And we're all on the same page about it because we have an understanding. And I mean generally, with the high level stuff, because there's always going to be some difference in opinion and perspectives and ideas and proposed resolution for the minor aspects of it all. But I mean for the major understanding, comprehension of what's going on, I want us to be there. And I want us to all have the same takeaway. And we're not talking about brainwashing. We're talking about comprehension so that we can have something to build resolution upon. Because we don't even have, and I love us so much. I love us so much. And I would imagine that there are some of our allies who have been wondering the same thing. I want to help, and I'm speaking from the allies' perspective. I'm sure that they're there. And raise your hand if you're one of those allies and you're like, you know what, I hear, that's how I feel right now. I don't really want to say nothing because I'm confused. No, don't be confused, because now be mindful about how you speak about that confusion. Be respectful, but you are 1000% correct. We have several different groups, subgroups within Black America, and we are not on the same page right now. Yet, high level, we all want the same things. But you can't really get us in the same room to have that conversation and draft this contract as Ice Cube has taken the helm. Well, I shouldn't say helm. He has allowed for himself to be the face of this effort, if you will. And of course, he knows that he is the celebrity face, whether he intends to be acting in his celebrity capacity or not. Because I don't think he's acting in his celebrity capacity. I think he's using his platform to push this, but I believe that he's acting from a place of sincerity. I really do. Okay? And I could be wrong because I don't know the man personally, but just based on everything that I've read and based on who he's rocking with, it just seems like it seems like his intentions are in the right place. Okay? All right, so we talked about constitutional law, statutory law, case law. Now we know that state law, right? That can be your statutory law as well. It can be case law, right? Okay. And then you have your court of appeals, intermediate. It is not a new trial. It's not a new trial at all. It is basically, it's a go-between. Just to be completely straightforward, it's a go-between. And it's not really for any particular party's benefit. And I admittedly used to believe, now of course with corruption, it has become the benefit of the prosecution, or it has become the benefit of the the inferior party, if you will, right? Or the losing party. So you just, there's a belief that if I lose in trial court, then yeah, I can keep appealing, but I'm just going to keep on losing until I get all the way up to the Supreme Court, if it's even heard by the Supreme Court, and it's just going to be a losing battle all the way through. Well, that's not true. And I invite you to look at the LexisNexis cases, because there are a lot of cases that are ruled unfavorably in the beginning, and then if someone just stays the course. And yes, I know that it can be very difficult and be very time consuming. And if you have to pay for your own representation and you can't represent yourself, and that's another thing, because you are lawfully entitled to represent yourself. Let me say it one more time for the people in the back. You are lawfully entitled to represent yourself. Okay, so oftentimes at the state Supreme Court level or the United States Supreme Court level, boom, decisions are reversed and remanded back to the trial court for further proceedings. Isn't that something? And it's something because we talk about this colloquially anyway, that what? Nothing worth gaining, what? Or nothing worth having is not done without gain, right? Without effort, excuse me. I'm bad with colloquialisms, aren't I? I'm terrible. But you get what I'm trying to say. All right. So how does this all relate to Breonna Taylor? Well, I just mentioned to you the issue of this qualified immunity, right? It does act, and it is wielded by corrupt jurisdictions as absolute immunity, right? Which police officers do not have. There's no body of law that I've seen, nor have I seen talked about in LexisNexis, nor would it stand to reason, because this is a Fourth Circuit of Supreme Court, United States. I'm not talking about, this is not, hold on. I'm not talking about the state Supreme Court. If you'll notice there, that is the United States District Court. Okay? So this case has gone well beyond just the state tribunal. Okay? And this court, Fourth Circuit, even if you think just federal district instead of getting to, federal Supreme Court, that's still a pretty notable opinion by the court, and especially to use the term Black Lives specifically, right? And at that level, and this is what I tell you, and this is why I refer to when I go to the political forums, and hopefully now this makes sense to you. When I'm at the political forums and I say that I am a former federal ranger, I use those terms intending to signify exactly what I'm about to tell you now. And what I've said to you before, and maybe it just was missed for whatever reason. Generally, and only generally speaking, because we do know that we have way too many corrupt people at in our federal legislative branch, right? We know that. We know that. We're not going to deny that. I've told you that there's 90% Caucasian men. Men far outnumber us. And Caucasian men, white men, they far outnumber everyone else in America in that legislative body. There are 500, and I believe to date in this 116th Congress. And when I say the 116th Congress, because if you get nothing from Evolve Weekly, you're going to be elevated in your awareness of the world going around you. Because I'm going to share everything that is in this little head of mine, okay? And actually, it's kind of, my head it's big, but it's proportionate to my body, okay? Thank you. All right. So, I definitely am a beautiful Amazon woman. And the scope of, colloquialisms. We'll keep going back to that term. I love that term. I think it's just an awesome term. But anyway, so, yeah. Whew. this is a very, very interesting thing. So we know that no-knock warrants are available in Kentucky. So I'm going to go to, and so we've established our assumptions, and now we're going to spend the next 20 minutes and we're going to discuss how this relates to Breonna Taylor. And it goes fast because, you know, I'm not trying to be funny, but again, I've already told you, for the most part, I have a good comprehension of this process, okay? And here's where the ethical and the legal divide comes into play. Okay. So the biggest issue here is the no-knock warrant. And it has been well established, the opinion of higher courts who have that precedential impact. And when I say precedential, not presidential, Precedential, it sets a precedent, right? So when these higher courts make an opinion, they send a decision, they reverse a decision from a lower court and send it back for further trial on their opinion, okay? It then says, hey, no. It's like a mother or a father to a child. No, I understand what you're trying to do, but that's not what we're going to do. It's not going to work like that. No. We're going to do it this way. So, and yes, do we generally know? Because, see, we're the people that are impacted day by day. And it is unfortunate. See, they're not, we said it a million times over. I've said it a million times over. They're detached. This is the problem that comes into play when we elect rich Caucasian men who very likely have had no real experience with day-to-day general life. They generally don't work a stereotypical form of employment that most Americans have at one time during their life. They generally have not worked as a server. They generally don't know what it feels like to collect $2.13 plus tips. So when they make their decisions about how the employment and that wage should be governed from their their status, from their chair looking down, they don't really have any true insight. And then too often, some of them, or too many of them, are in a position where they don't understand the plight. They don't understand even the insight if you were to share it with them, because they've not experienced it themselves. This is why our parents, they suggest that we, work a general labor job, right? Just so that you understand what all goes into it, so you have an appreciation for when you gain that awesome job. Or you open your own business and you work for yourself. And then you have an appreciation for your employees because you've been one before. And it's okay to go through those processes. It's also okay because there are in existence those individuals who have become the employer, or have always been the employer, but they still have a good foundational stance from their parents. Maybe their parents had those values from their parents, and so they, pass them along to their child who's never worked a traditional job, but has a full understanding. Well, this is what we have into play here, because surprising someone at home, when you have police officers coming in with loaded guns and drawn, come on, friends. I know, from my perspective, from my set of understanding, I know immediately. We don't need to sit in a room for 3 hours and talk about how this can go wrong. This can go left immediately. Immediately. And I'm not talking about IMMEDIATELY. I'm talking about the one with the J in it. Immediately, okay? Or the G. It can go left quick. Why would you think that this would be a good idea ever? Why would officers put this on the books? or why would officers and legislators work to put this on the books? Why would this be in place in the first place, right? And then we know that this goes back to a time where we were what? Or, we were classified as 3/5 human. And that's still in the Constitution. That's another thing that, oh Lord, that has to come out. If you want a good relationship with someone, and see, for us, this is common sense. And when I say us, I mean generally African Americans like myself, or anyone who has experienced any form of bias against them, discrimination, or has lived with low income, or is part of the lower to middle class. And I hate to use those terms because I don't like to gradate. You know that I don't like gradation at all. But the point I'm making is that those things are stupid easy for individuals who have experienced something. If you've lived a little part of life, well, this is not going to work. This is going to be bad off gate. I don't think we need to put this. I think we need to always, and forever always have the knock, announce requirements and the verification of the warrants always there. And let me also tell you that the verification of the warrant, that's also inherent in the issuance of the warrant. That is the responsibility and liability of the court to not issue warrants that are not on sufficient evidence. You have to have sufficient evidence, and oftentimes they'll say probable cause is sufficient. But there are definitely courts that will stand their ground. There are judges who will stand their ground. I know that you may not believe that because we're not seeing all of those cases. There are good judges out there. There really are. And they will stand their ground, and they will not allow for the issuance of a warrant just on the basis of circumstantial evidence. Even if this police officer, this investigator, this detective can prove or can argue, very convincingly that it will result in the discovery of probative evidence. Okay? But the problem is that the judges are not all ruling in the same fashion. And so this is where it comes into play, where I would propose some type of, not so much as like a robotic system, but we need, because I know that there's, unique circumstances and all that kind of stuff. So every case can be different. But we need to get on this commonality. I think the commonality is all the scientific method. I think that's where I'm going to lend greatly and very positively to being with you all in this process. I don't know how it's going to look going forward, but I know in the next 4 years, at the very least in the next year, well, we know with this term, the next administration, the 117th Congress, we know that it will look like we've always known, right? There may be some change and transformation throughout this process, but generally the framework will be the same. The methodology will be the same. So what I'm referring to is that, and let me get out because I'm not turning into a, what is it? What's the darn? A Vulcan. It looked like I was turning into a Vulcan there for a second. I've got light over here and the fire, and it looked like I had some good old ridges over here. But I do like Spock. I rock with Spock. I do identify like Spock. But anyway, this commonality, and I've heard people propose before that we need to have less laws, right? And I think that might just be a bit dangerous to just go with that as the end-all, be-all decision. But I understand completely where they're coming from, because they're like, if you look at the laws from state to state and the case law, not just the statutory law, but the case law that can be used against someone, because it can be a case that was ruled only 2 weeks ago. If you have an apt enough and a diligent enough licensed attorney who's actually going to delve into those cases, those decisions in those courts, especially if you're at the same jurisdictional level. So what I'm referring to, if you're in district court in a county, right, and there's a decision a week before, and it's basically on the same type of unique circumstances in your case, and you have an attorney, or you do your due diligence and you look up similar cases and you see it and you see the decision made and it was made by the same judge who is adjudicating your case, friends, score. But as it relates to Breonna Taylor, this is what's going on. You have laws that have been on the books that are completely antiquated. They no longer apply to the unique circumstances of our individual communities, what we've experienced. We don't have a good experience. African Americans do not. We have been consistently profiled, consistently treated as inferior, regardless of our beautiful, superior stance. No matter if we are, quote unquote, playing the role and we jump through all the hoops, we still generally get discriminated against consistently in a pattern, in a deliberate, intentional, knowing, malicious pattern on a regular basis. So we are already traumatized. And if we're sitting in our house and we already know that it's commonsensical, if someone were to roll up into a Caucasian man's house, guns drawn, we already know that generally speaking, a lot of them are in support of the what? The Rifle Association, right? The NRA. So we know generally from what we've seen, what they say out of their own mouths, that they're gun-toting citizens, right? And we know that they're going to defend their house. They always make that very clear as well. So then why wouldn't we? Why wouldn't Breonna's boyfriend defend himself and his girlfriend? Now, I'm not going to go into the details about whether or not there was some foul play by her boyfriend, because there's so many circumstances there. And there's just not enough probative evidence. I don't even see enough probative evidence. I don't know the ballistic report. That will be another thing that I'm going to look up, because there will be a part 2 of this. But it's necessary for us to do this without question. Okay? We need to be on the same page. But if we're starting with a basis of law that does not consistently or is not consistently applied, irrespective of socioeconomic status, race, circumstances, there's always going to be a problem. And inseparably, indisputably, they cannot, because I just gave the scenario, they cannot say, oh, no, I would just sit there and because I would know it was the police, and I would say, hey, police, I see your guns are drawn. I'm calm. I'm just watching TV, and I don't have any fear of you whatsoever, and I'm not going to protect myself, even though I have no idea who's in my house. Hi, officers. How may I help you? We know that's a lie. And we know that if officers' guns are drawn, and then if a resident who is not expecting anyone to come into their house, they draw their gun, believing, and justifiably so, believing that they're going to what? Defend themselves. But what? This is like the movies that we see, right? And if somebody fires, which we know, generally speaking, the first person that's going to fire in this situation, because why? We know this mathematically. We know the reason why we know this mathematically is because if they see a gun, the first thing that and I'm saying the police, because I'm pointing their way. We got the police over here. We got the Breonna and her boyfriend here. And of course, this is not the exact stage reenactment. But what I'm getting at is that we know generally in all of these situations, the officers have fired first. There has been no fire from the assailant, the victim, the purported perpetrator. It has always, the first shots have generally, not always, But I said generally, and in most cases, it has always come from the officers first. And it was no different here. If, of course, we're getting the full story, because we know that there's always going to be a part of these incidents that we will never have full disclosure. I would love to, and that's what I'm going to try to obtain. I don't know how well I will be able to do this as far as looking into Louisville, Kentucky records and things of that nature. And yes, they say that they have made some changes and they have abolished the no-knock warrant. Let me just get a date on that. But that doesn't solve our problems. That does not bring Breonna Taylor back. That does not resolve the issue of the express fact that I've said this a million times over, and I will repeat it again. Officers should be marksmiths. We know that they're going to be human all day long. So I don't want to hear anybody's argument. Do not post anything on my page talking about well, people are human and in those heightened situations. No. See, that's the point. That's why you go through and you undergo training. And if you're not prepared, or you experience some psychological catastrophe or physical catastrophe that results in a psychological trauma as a police officer, you should be required. You should be enjoined. In fact, you are enjoined, but you're acting as though you're not. And I'm speaking to police right now, those police who would think that they are not bound to report their psychological trauma to their superiors. And in that moment, you need to sit down. And then you need to agree and understand the reevaluation of your ability to be out in the field. Because we're talking about people's lives. This is not a test. You're not shooting at dummies. You're shooting at people with lives, with children, with partners, with friends, with liberty, with rights. Human rights that take precedence over legal rights, even though there has been a switcheroo of that, it seems, that benefits the police under exactly what this case refers to. And again, that case, if you want to look it up, is Jamison versus McClendon. And also, let me give you the keywords that I looked up when researching this matter and decided what I was going to talk about. I keyed in, of course, Breonna Taylor. And then I keyed in no-knock warrant. And I got some very interesting things. And in fact, ironically enough, there are other cases that are now licensed attorneys are using previous opinions on the Breonna case for other cases. And I imagine that this will continue to emerge. We'll see this. And so this should be very interesting. This should be subject matter that you kind of bookmark, right? So let me go there. Let's go to Kentucky statutes. And I've told you a million times over there as well that all the statutes have to be publicly promulgated. And that's within the stipulations of law. And I've told you why. Well, if we can't be ignorant of the law, if ignorance of the law is not a defense, is not a viable defense, then we have to be informed. Now, they don't say that you have to be sufficiently informed. I believe and I assert that that's another form of transformation that we need, because we are not generally sufficiently informed. Now, even where I may be sufficiently informed more than others, I still yet am not sufficiently informed of every law that would apply to my life and my circumstances. And to be honest with you, it concerns me regularly. Now, I don't lose sleep over it, because I generally know how to defend both myself and my family and my mom and my son and my future husband out there. He's out there somewhere. And my extended family or whatever. But it can be concerning because there have been times where I have read in law, like here's a good one. I'll use one for myself, and it relates to the Breonna Taylor case for this reason, okay? So during my pregnancy, I had to take hydrocodone. Hydrocodone is Vicodin, right? All right. So there is a stipulation in law that if you're driving while under the influence, that prescribed drug, that prescription is not a viable defense against the crime of driving while impaired. I didn't realize that at that time. As soon as I saw it, I was like, well, damn, I guess that does make sense. Now, and I've told some of my friends, now this is going to be a very interesting thing, and then I'm going to jump off here in the next 10 minutes. This is going to be a very interesting thing. Now, for some of us who have mastered, or you have a intermediate or more advanced level of being able to control your mind and enlightenment and meditation, you can actually, I jokingly call it, outsmart a neurological agent, right? And it's specific. I'm not talking about the stuff we see in the damn non-fiction movie, in the fictitious movies and things like that. I'm not talking about that. I'm not like some meta-human. I'm just telling you that pain is a neurological inflammatory response, right? And so pain has basically what I'm saying is all discoveries and all research has led down the road to the discovery that inflammation is all that we best understand about pain. We don't understand exactly where it comes from, and we know that it can be neurologically manipulated. And so I've learned how to manipulate that inflammatory response, or that neurological response. And so I can take a hydrocodone, and I can decide neurologically to allow it to help me with my pain. And that's when I realized that, you know what, I know that I don't need this because I can actually outsmart it. I can outsmart my pain. I can think beyond it. I can meditate beyond it. I can cognitively decide that I'm not going to focus on this pain. Now, of course, there are times where, and we're not talking about, the severity of pain. This can be different, but your resilience and, of course, your ability to, deal with those things, they matter. So how does this matter to Breonna Taylor? Okay. The no-knock warrant. Clearly, her boyfriend, nor Breonna, I can't say clearly. Clearly, we know that her boyfriend was not sufficiently informed about the provisions allowed or afforded to police officers to be able to come in and in the manner that they did. Okay. Excuse me, I'm going to pull up something. I'm going to pull up the statutes. I found this article very interesting, and I'm going to go to it real quick before I have time. And I'm going to suggest it for reading for you as well. Let me see. Come on. And these are very, very interesting opinions. And I really do invite you to look up these opinions, because they have, the plaintiffs have really done a very excellent job in also incorporating in their arguments the history and pattern of practice of discrimination that African Americans have suffered as an aftermath from slavery. And that's what I want you to, there we go, here we are. I had it tabbed there, so I apologize. Give me 1 second. I know I'll be able to pull it up. Or maybe I need to go up. And in fact, I also want to highlight this as well. The Fourth Circuit stated, they concluded, in fact, this has to stop. And this is referring to the taking of Black lives, the murdering of Black lives, and then usurpation of this qualified immunity under the guise of absolute immunity. Okay, hold on. Where is that? Come on. I should have written it down. It's something like the days and hours. Let me see if I can Google it. Maybe I can, since I can't see it for looking. Days and hours. Breonna Taylor. Let's see if I can, because it's in the book. A minute-by-minute timeline of the events that led to her death. They executed, and a lot of you have already read this, and I'm trying not to just go over stuff that you've already read. So Jamarcus Glover, we know, who is Breonna Taylor's ex-boyfriend. He was arrested, and this is involving guns and narcotics. So the guns and narcotics element of it satisfies the element of danger that is necessary for issuing or substantiating a no-knock warrant in the first place. So the guns and narcotics and their investigation into whatever was going on with Jamarcus Glover, the previous ex, right? When I say previous ex, of course, now the other gentleman, he is an ex, so that's what I'm referring to. So the boyfriend prior to her boyfriend at the time of the entry into their home at the execution of the warrant, right? So that's why the no-knock warrant was merited and substantiated and issued. And we see that we know this because it was then executed. The problem is that, again, when you catch those off surprise who are not necessarily directly related, therein lies the anger and the disgust that the general public has for it, because we don't have any problem with the police doing their job. We have a problem when they fail to do their job correctly and do it ethically and do it consistently. Like, if we're going to do it this way for Black America, then you need to do it this way for rich white Americans who can afford to buy a judge and, and get off on murder. We want this to be consistently applied, right? So there is some, there's substantiation there for that specific aspect. And this is why I keep telling you, at the end of the day, what has to change is legislation. I've told you this a million times over, and I will continue to tell you. And then the other part, because don't let anyone get it twisted for you. Once legislation is ratified, be cautious and be constantly aware, because what can then happen is the misinterpretation of the law on the books, the statutory law. Even it happens as it relates to case law. And they do this, and it's called what? Obfuscation, that word, which means to confuse the facts of something or confuse the interpretation, the generally accepted interpretation of a thing, and to confuse that intentionally for your malicious motive, albeit to get off of being charged with a crime, to protect someone who you know otherwise would be convicted of a crime. This is the situation here. And I believe what we have here is a situation of obfuscation. Okay? So this is why I believe that they're suggesting, or this is why the attorney, the state, what is his name? I can't think of his name. I guess because I don't want to think of his name. Let's see. So this, yes, and I was reading something that I hadn't seen before. But this is why the state would have that disposition that it's like, okay, state DA, the Attorney General, what do we need? No, we're not going to move forward with these charges. Why not? Why not? Because it resulted in the life of someone being taken. However, now we go back to, and I'll discuss what I just read in the next part, because this is going to take a while and this will make me go on a different tangent. This is the first time I've looked at this particular article in the Courier Journal, because again, it was referenced in the LexisNexis file that I found. Okay, so let's go to murder, the definition of murder and the elements of murder. So the general kind of model answer for the definition of murder is the unlawful or killing of another, okay? Then you go into the different degrees, and you have without justification or valid excuse or provocation, right? You have premeditation, you have defense, you have your malignant heart, your state of mind. Malignant heart just means like with malice, right? Was this involuntary manslaughter? Did you intend this? Was it in the act of another incident? Was it in the act of another felony, which would, arise to the felony murder rule? And that just basically means if you're committing a felony which results in someone's murder at your own hand, then you can be charged with murder as well. If someone else, hold on, good gracious, because that seems self-explanatory. Hold on a second, because I feel like I misspoke. I don't want to misspeak. Yes, it applies when someone commits a certain kind of felony and someone else dies in the course of it. It doesn't matter whether the death was intentional or accidental. The defendant is then liable for that death, right? So like if you're committing a robbery and you didn't turn the gun to someone and shoot them with the gun, but let's say you shot toward the glass or something, and something fell on them which resulted in their death, then you can be charged with that murder, irrespective of the mitigating circumstances that would otherwise make it maybe manslaughter, voluntary manslaughter, or something like that. So the reason why I'm going into all these details is that, okay, and that's the reason why her boyfriend has been charged in one regard, and it really is just a cluster fuck. And I'm not going to say it any other way, because this is what it is. It is on full display, everything that I have been telling you. Our laws, we have too many of them. And sometime a long time ago, and I'm going to wrap it up right now at 4:15. Sometime a long time ago, they were like, okay, well, we're going to start here. This should be a good basis. And I'm not even going to go into whether their intentions were good or what. I don't know, because at that time they considered me 3/5 human, so they definitely didn't have any good intentions towards me. Okay, so but let's say generally here we are. This is what we're going to have, and this should work for us generally. And this will be our plan. Our plan will be that if things arise that are new circumstances, then we'll have judges who we will properly train and who should be upstanding in our community and be able to make these decisions and do it in an unbiased manner. Now, how are we going to do this? Because you see so many of these judges who are opining off record. They've made their stance very known. And I believe that there should be, and there are rules of conduct, or canons, CANONS, against them having these public opinions. And I think that's the reason why Amy, took that disposition to pretend, to feign that I have no opinion outside of the objectivity of the office for which I have received a nomination. Bullshit, okay? You have a very clear opinion, and it's evident in your rulings, especially where you would go off book. When you go off script, when you go off statutory law, even when you go off case law and you start making your own opinion, you are then becoming an interpreter completely, solely. And that's necessarily going to be directly connected to how you were raised, what you believe in, what you've experienced, what you experienced last week even, as opposed to 2 years ago, because we change over time because of the experiences that we have. Whether you think women's rights should be upheld, and that has a lot to do with the marriage and the circumstances of your own the marriage that she has, and how she views her children, and how her husband views her children. All those things are necessarily in there. That's why I propose some type of robotic application, but that wouldn't work either, and we already know that. So I am only saying loosely, loosely speaking. I wish there was a magic button where you could just, okay, here are the circumstances. You put the piece of paper into what we've already programmed with this rubric, and it pulls out a decision that will be consistent each and every time for that same set of circumstances, right? But no, we love to argue all up and down the street, around the corner, we like to argue our self-righteousness. And this happens even with the judges, and this is what continues to happen. So basically, the reason why Breonna Taylor is dead is because our system is fucked up. There's nothing in the understanding of how law has compounded, and I'm talking about the statutory law. Every time they ratify something, they don't necessarily, yes, they're going back every once in a while and you'll see that they have repealed a statute because it doesn't apply, right? But they do this over the course of an entire year because it takes them forever, right? We elect these legislators into place, and they spend more time vacationing and on say it. Lord have mercy. I can't believe that word just left my brain there. Basically, they're on hiatus. I can't even think of the word for whatever reason. You see, I'm human. I'm human. I'm Amazonish and near perfect, but I am human. Okay. All right. So while they're in this, in this period, these periods far outweigh in number any other active session that we've had them in. And it works the same way with our Congress at that level, at the federal level. So whereas there could be ratification of so much more during this period to really catch up to the gaps. They're not doing that. So when we look into the Constitution, this is why we see so much antiquated law, because they're not timely ratifying and repealing stuff that no longer applies or that needs to be revisited and amended. And this is what we have. And so in that regard, specifically, the state of Kentucky should be held fully liable for her death. But you know that they're only going to do that in a civil process, which means they're going to think that, I give you $3, $4, $5 million and that should be sufficient. No, because then it's going to happen again, and it's going to happen a year from now, and it's still not going to be taken care of. Even with them eradicating the no-knock warrant, please understand that there are other ways that they can still have the substantiation of being able to come into your home and draw a gun and not have you have that forewarning, that proper vetted process that we all see as commonsensical actually followed. And even if it is followed, it still results in these one-off occasions, which have become more than just one-off occasions, where oftentimes our people are being targeted. What is the issue? What is the foul in targeting Glover directly? Why do you need to go into any house that he's in? Come on now, friends. If you're a detective, and at the federal level, you would be able to monitor that individual person. Go after that individual person. And if during that investigation, you see that person, they directly observe that person with another person, go in and make the arrest then. I do have to say that I believe very strongly that this really messes up the process. I know some people are like, well, Tigress, but, and I'm talking about detectives. They're like concerned that if they jump too fast, they will lose the opportunity to really to discover all of that person's co-conspirators and Lord have mercy. Anybody involved in that crime in any way, shape, or fashion. What you're not understanding, though, is that you're leaving them to do all of their injustice and cause this ripple effect that happens and that somehow brings in all these other individuals indirectly and both directly into the fold of this investigation that is on this specific person. Just go after that person. And believe it or not, everything that I have seen in my federal uniform, trust and believe, anybody who is committing crime on a regular basis in the regular conduct of enterprisal criminal activity, trust and believe you're going to get another opportunity to get them. You're going to get another. They're going to give you lots of opportunities to get them. So that's where I'm going to leave this right now. That's how I feel about this. So yes, definition-wise, and this is exactly what T.I. was talking about. We're not talking about politics, sir. I can't even think of his name. What is his name? The state. Lord have mercy. Hold on one second. Let me get his darn name. He done ticked me off so much. D.A. Kentucky. Breonna Taylor. Daniel Cameron. Okay, there we go. We got his name. Attorney General Daniel Cameron. So, yes, when we look at a definition and we look at the definition only, and it's 4:20, so I got to go. We look at the definition only, then, of course, without question, you can say from that aspect, right? You can say, oh, well, definition, here's our if-then. If this, then that. No, this is where we have the most contention, those of us who truly have a full comprehension of the law. It's not applied the same way for individuals that don't look like us. All of a sudden, there are mitigating factors. There are exigent circumstances. This is why we look at this and we say, from our commonsensical perspective of everything we deal with every day, because please understand that African Americans, we understand completely, and I'm talking to so many different sectors right now, and I think that when I address you during my live sessions, you know who I'm talking to when I speak, okay? So this sector I'm addressing very directly. Understand that African Americans, we have a full comprehension of the why a no-knock warrant would even be discussed. We've seen enough movies. We've seen criminal activity in our neighborhood. We know that those who intend to have criminal enterprise be their way of life, we know that they are very, very manipulative, and they're very good at buying an attorney and buying a judge and getting off. We know that they're good at hiding drugs and hiding this and then terrorizing our neighborhoods, bringing that filth of drugs into our neighborhoods, tearing our families apart, all this inter-destruction that is going on and it's just so disgusting because it's so self-destructive to our communities. So we understand where there would be the applicability of a no-knock warrant. But if it's going to be used in this fashion to terrorize others who have nothing to do specifically with your investigation, this is where our contention lies. And Breonna Taylor specifically did not deserve what she got. It is not even clear how much she even understood or knew about the investigation that was going on with her ex. And I'll even go this far as well. Black men, beautiful black men. Black women have stood behind you and beside you and around you and in front of you and have covered you with love that you don't even deserve sometimes. And vice versa, you've done the same for us. But also, and I know a lot of you are going to be very upset about this, but you know, objective mama, who also is to blame is Glover. Glover exposed Breonna Taylor to this. Too often, even myself, I've been in a relationship and did not even know the full weight of what an individual was doing, what my ex was doing. And that's why I'm so mindful now, having had my son and knowing the lifestyle that I choose. And still, again, we're right back to square one. I still very much so enjoy doing lots of hood things, but not hood things that are going to result in my death or harm, or nor that of my son or my mother or any of my loved ones, because I don't want to expose them to any of that stuff. I wouldn't be able to forgive myself. So the first tortfeasor, or the first perpetrator, the first criminal act was done by Glover. And let me be very clear to white police officers who would watch this, or naysayer police officers who would watch this and try to use this as some sort of defense for them not charging the police officer with murder. Kiss my ass. No. Okay? I'm just handling this completely objectively. At the end of the day, Breonna Taylor should still be here. The blood is on the judge's hands who issued the no-knock warrant. The blood is on the hands of Glover for exposing Breonna Taylor to that life, because clearly she had moved on. The blood is on the hands of the legislators who ratified the law to allow for the no-knock warrant in the first place, without specifying this very thing that I have mentioned to you as a former federal ranger, that the investigation should be exclusive to the criminal perpetrator. Unless, of course, and that's in there, it's inherent, it is an explicit thing. You need to focus on the person committing the crime. Because at the end of the day, I don't care how much you think someone else is aware of the criminal activity of another. Very often, too often, the individuals those who decide to engage criminal activity have around them, they generally don't know the full weight of their criminal activity. And even where they would seek to get away from it, the way that investigations are being handled and no-knock warrants are being handled, it will necessarily always pull into the fold innocent people. who just happen to be accompanying in one aspect or another the person who is under investigation. So I'm done. I've gone over my time. We're gonna do a part 2 on this, but I hope that I have enlarged your thought. I hope that I have expanded your objectivity, and I hope that I have not caused further divide. I believe that this skill set of mine, this lens that I have, these special glasses, are available to us all. And I believe that these special glasses we need to use to form a more perfect union. I'm Tigress McDaniel with Evolve Weekly. Join me next Sunday at 4 p.m. Have a wonderful week and be safe and protect your neck. Wear your mask. Y'all have a good one.